The committee will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. The Oversight Committee's mission statement is that we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know that the money Washington takes for them is well spent. It's our job to work tirelessly in partnership with citizen watchdogs, and yes, the IG watchdogs, to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is our mission statement. On August 5th, 47 Inspectors General, two-thirds of the IG community, sent an unprecedented letter to Congress describing serious limitations on access to records that have recently impeded the work of the Inspectors General. Section 6A.1 of the Inspector General Act of 1978 requires agencies to provide, and I quote, full and timely access to agency records to their respective Inspector General. Anything less than full cooperation, of course, is unacceptable. These government watchdogs play a key role in improving the government's efficiency, honesty, and accountability. They conduct oversight and investigations and audits to prevent and detect waste, fraud, and mismanagement within government agencies. Their work often protects life of Federal workers and the American people. They help Congress shape legislation and target our oversight and investigative activities. But let there be no doubt, they are executive branch employees who, in fact, were created by an act of Congress and signed by a President so that the tools that they provide are available to the President of the United States to run our government better. The IGs have proven to be one of Congress's and the American people's best investments. In the last fiscal year, the IG community used their $2.7 billion budget to identify potential cost savings to taxpayers totaling about $46 billion. That means that for every dollar in the total IG budget, they identified approximately $17 in savings. Access is key to that kind of savings. But let me make it very clear, many of the investigations, including some you will hear today, are not about money. They are far more valuable. They are about liberty. They are about your government not trampling on your rights. So when agencies withhold information and their records from these watchdogs, it impedes their ability to conduct their work thoroughly, independently, and most of all, timely. It runs up the cost to both sides of the ledger. The Inspectors General spend many, many, many millions of dollars simply trying to get access, while your government, the very same agency, spends millions and millions of dollars on lawyers trying to impede. This is one of the greatest wastes we could possibly have. When agencies refuse or deny IGs access to agency records, it undermines the intent of Congress and the IG's ability to effectively oversee these respective agencies. Today, we are going to hear from three widely respected IGs who have faced serious challenges from their agencies to access the necessary records to what they do in their work. At the Justice Department, the Inspector General cannot gain access to grand jury documents or national security-related documents without approval and delay from the Deputy Attorney General of the Federal courts. Requiring such permission compromises and impedes IG's investigations. At the Chemical Safety Board, They have denied the EPA Inspector General, Mr. Elkins, who is with us today, access to certain documents on the basis of attorney-client privilege. But who is the attorney and what is the privilege? Mr. Elkins is, in fact, the same entity that is, in fact, the client. He is, in fact, part of the defined client, which, of course, is the EPA. Further, several offices within the EPA itself, including the EPA Office of Homeland Security, have interfered with the OIG's investigations themselves. And perhaps most disturbing to me personally, and I spoke to the Vice President last night, and I believe he was equally disturbed, at the Peace Corps, they have refused to provide the Inspector General, Ms. Buller, access to information related to sexual assaults on Peace Corps volunteers absent a memorandum of understanding. Let's understand, last night we honored and celebrated the 20th anniversary of the enactment of violence against women, designed to do just the exact opposite, to ask women to come forward and report their assaults. If, in fact, the IG cannot oversee a possible pattern of failure to protect women, then are we to ask women to come forward with the record of their assaults? But in all instances, it is the committee's position that these agencies should and must cooperate with the Inspector General's request for information. During the 113th Congress, the committee has investigated several instances, including the ones facing these watchdogs, in which agency leadership undermined the effectiveness of the Inspectors General. The committee has held several hearings on this issue and facing these Inspector Generals over the past year. The committee has also conducted a deposition of the Peace Corps General Counsel to address the access issue at the Peace Corps. It has not been resolved, and quite frankly, I look forward to the departure of the General Counsel as part of the problem. Neither this committee nor the IG community should be wasting time and resources attempting to gain access to records which the IGs have not just a legal entitlement to, but a sworn obligation to under the IG Act. For nearly 6 years, we have seen this administration make unprecedented efforts, it says, to fight transparency and block investigations by journalists, Congress. But that's not what we're here for today. We're not here because the press wants to snoop. We're not here because Article 1, the Congress, is trying to look over the shoulder of the President and his administration. We're here because the more or less 12,000 men and women who work for these IGs and the others not here today, part of this President's team for efficiency, transparency, and, in fact, an honorable service by all, has not been getting what they wanted. It is my intention, upon the end of this hearing, to write with my ranking member, if at all possible, a letter to the President urging him to use his executive order capability to resolve this question once and for all. Notwithstanding that, I want to thank our 3 witnesses here today, and I want to assure you of one thing. After you testify here today, and for all 47 IGs who wrote, I will be looking, I know my ranking member will be looking, to make sure that, in fact, no retribution, no punishment is allowed for your coming forward and expressing your concerns under your responsibility, the IG Act. With that, I would ask just one thing. We do have a response from the Executive Office of the President, the Office of Management and Budget, in response to Mr. Cummings and my letter, and I'll place it in the record at this time without objection. So ordered, and we recognize the ranking member for his opening statement.
Thank you very much, Mr. Chairman, and I want to thank our witnesses for testifying here today. I want to also thank the Chairman for calling this hearing. Let me start off by saying that what the Chairman said with regard to retribution, I agree with. you do a phenomenal job, a very important job. And every member of this committee, both sides of the aisle, if we hear about any repercussions from you being here, we will be on it and deal with it effectively and efficiently. Rooting out waste, fraud, and abuse is a central tenet of this committee, and we take this mission very seriously. I'm a staunch defender of the IGs and their authorities. And, for example, in 2013, I sent a bipartisan letter to the President. I was joined by Chairman Issa as well as Representative Chaffetz and Representative Tierney, the Chairman and Ranking Member of the National Security Subcommittee. In that letter, we pressed the President to finally nominate an Inspector General at the State Department, a position that had remained vacant for 5 years. I've also supported legislation to help IGs do their job more effectively and efficiently, such as the IG Reform Act of 2008. Last month, after receiving the letter from 47 IGs, I co-signed a letter with Chairman Carper and Ranking Member Coburn of the Homeland Security Committee and the Government Affairs Committee, as well as Chairman Issa. In that letter, we expressed our bipartisan concern to the Office of Management and Budget about access issues raised by 3 IGs testifying here today from the Peace Corps, the Department of Justice, and the Environmental Protection Agency. When Congress passed the Inspector General Act in 1978, Section 6 of that legislation authorized IGs to have very broad access to agency records. And this provision was intended to give IGs wide latitude to conduct their audits and investigations, but Congress also included certain exemptions on the legislation, some of which are an issue today. In addition, some contend that other Federal laws may conflict with this broad grant of authority, and that is also a concern that we will be discussing today. First, we have the Peace Corps. In 2011, Congress passed and the President signed the Kate Pussy Volunteer Protection Act. This law requires the Peace Corps to establish a confidential system for volunteers to report sexual assault crimes. When the IG sought access to this data in order to prepare a report also mandated by Congress, the Peace Corps raised a question about providing the personally identifiable information of sexual assault victims, which was supposed to be confidential. On May 22nd, the agency and the IG signed a memorandum of understanding, providing the IG with access to all information except personally identifiable information and explicit details of the sexual assaults. I understand that this agreement does not address all the IG's access concerns, but I believe it is a very good start when we have 2 potentially conflicting statutes like this. Next, the Department of Justice Inspector General has expressed concern that when he seeks access to sensitive law enforcement information, such as grand jury and wiretap information, he must go through a lengthy approval process at the highest levels of the Department. The IG's testimony for today says the Department has granted access to the records in every case, but he contends that the lengthy delays erodes his independence. According to the Department, several other statutes restrict the release of sensitive information, such as grand jury and wiretap material. So they must be carefully analyzed, and we have to look at that. My understanding is that the Department has now asked the Office of Legal Counsel to review the issue. I applaud the IG for working through this process with the agency, and I look forward to OLC's review. Finally, the Environmental Protection Agency, IG, has raised 2 concerns. The IG reports that the EPA's Office of Homeland Security has been denying the IG access to classified threat material and failing to recognize the IG's statutory authority over intrusions into EPA computer networks. Democratic staff has been working with both sides to mediate this issue, and on June 19th, EPA Administrator McCarthy proposed a framework for better cooperation. At this point, my understanding is that the IG still has issues with the proposal, so I hope we can spend some time today hearing about those concerns. Lastly, the dispute between the EPA, IG, and the Chemical Safety Board seems, at least to me, to be the most problematic. The IG has been trying to obtain documents from the CSB chairman, but the CSB still has not produced all of the requested documents. This week, the IG's office sent a letter explaining that although the CSB had complied substantially with requests, documents still remain outstanding. I hope we can work with you closely on a bipartisan basis to solve this issue. Let me close by making one observation. As we have seen, many of these issues involve several laws that appear to conflict, and some have raised the possibility of legislative fixes. I believe this idea should be considered very carefully. Although I will not hesitate to pursue statutory clarification if necessary, the last thing the IGs need is for legislation to be introduced and fail, which could have the unintended effect of diluting their authority. For these reasons, Mr. Chairman, I appreciate your commitment to work with me and my staff in developing bipartisan and widely supported legislative reform proposals. My staff and I have devoted tremendous efforts to helping IGs do their work, and my goal has always been to try to solve the challenges constructively. And with that, I yield back.
I thank the ranking member. All members will have 7 days to submit opening statements for the record. We now welcome our distinguished panel of witnesses. The Honorable Michael E. Horowitz is the Inspector General of the U.S. Department of Justice. The Honorable Arthur A. Elkins, Jr. is the Inspector General of the U.S. Environmental Protection Agency. And the Honorable Ms. Kathy A. Buller is the Inspector General of the Peace Corps. Ladies and gentlemen, pursuant to the committee rules, would you please rise to take the oath and raise your right hand. Do you solemnly swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record reflect that all witnesses answered in the affirmative. Since you're all skilled professionals, and Mr. Horowitz, since you're less than 24 hours from a similar event, you know that we'd like you to keep your opening statements to 5 minutes, summarize in any way you can, and that your entire opening statements will be placed in the record without objection. And with that, Mr. Horowitz, you're up.
Thank you, Mr. Chairman, Congressman Cummings, members of the committee. Thank you for inviting me to testify today at this very important hearing. Access by Inspectors General to information in agency files goes to the heart of our mission to provide independent and nonpartisan oversight. That is why 47 Inspectors General signed a letter late last month to Congress expressing their concerns about this issue. I want to thank the members of this committee for their bipartisan support in response to that letter. The IG Act adopted by Congress in 1978 is crystal clear. Section 6A of the Act expressly provides that Inspectors General must be given complete, timely, and unfiltered access to all agency records. However, since 2010, the FBI and some other Department components have not read Section 6A of the Act in that manner, and therefore have refused our requests during our reviews for relevant grand jury, wiretap, and credit information in its files. As a result, a number of our reviews have been significantly impeded. In response to these legal objections, the Attorney General of the Department or the Department Attorney General granted us permission to access the records by making the finding that our reviews were of assistance to them. They also have stated their intention to do so in future audits and reviews. However, there are several significant concerns with this process. First and foremost, the process is inconsistent with the clear mandate of Section 6A of the IG Act. The Attorney General should not have to order Department components to provide us with access to records that Congress has made clear we have a right to review. Second, requiring the Inspector General to obtain permission from Department leadership seriously compromises our independence. The OIG should be deciding which documents it needs access to, not the leadership of the agency that is being overseen. Third, While current Department leadership has supported our ability to access records, agency leadership changes over time, and our access to records should not turn on the views of the Department's leadership. Further, we understand that other Department components that exercise oversight over Department programs and personnel, such as the Department's Office of Professional Responsibility, continue to be given access to these same materials without objection. This disparate treatment is unjustifiable and results in the Department being less willing to provide materials to the OIG, presumably because the OIG is statutorily independent while OPR is not. This disparate treatment again highlights OPR's lack of independence from the Department's leadership, which can only be addressed by granting the statutorily independent OIG with jurisdiction to investigate all alleged misconduct at the Department. Indeed, the independent, nonpartisan Project on Government Oversight made the same recommendation in a report issued in March of this year, and bipartisan legislation introduced in the Senate would do just that. This past May, the Department's leadership asked the Office of Legal Counsel to issue an opinion addressing the legal objections raised by the FBI and other Department components. It is imperative that the OLC issue its decision promptly, because the existing practice at the Department seriously impairs our independence every day we do our work. Moreover, in the absence of a resolution, our struggle to access information in a timely manner continues to seriously delay our work. It also has a substantial impact on the morale of the OIG's auditors, analysts, agents, and lawyers who work extraordinarily hard every day. Far too often, they face challenges getting timely access to information, including even with routine requests. For example, in 2 ongoing audits, we had trouble getting organizational charts in a timely manner. We remain hopeful that OLC will issue an opinion promptly that concludes the OIG is entitled to independent access to the records and information pursuant to the IG Act. However, should an OLC opinion conclude otherwise and interpret the IG Act in a manner that results in limits on our ability to access information, we will request a prompt legislative remedy. For the past 25 years, my office has demonstrated that effective and independent oversight saves taxpayers money and improves the Department's operations. Actions that limit, condition, or delay access to information have substantial consequences for our work and lead to incomplete, inaccurate, or significantly delayed findings or recommendations. I cannot emphasize enough how critical it is to get these pending access issues resolved promptly. Hopefully, OLC will issue shortly an opinion, finding that 6A of the IG Act means what it says, namely that the OIG is entitled to have complete, timely, and independent access to information in our agency's files. This concludes my prepared statement, and I would be pleased to answer any questions you may have.
Thank you, and you'll yield back the 1 second.
I'll yield back the 1 second.
Thank you. Mr. Elkins.
Good morning, Chairman Issa, Ranking Member Cummings, and members of the committee. I am Arthur Elkins, Inspector General for the Environmental Protection Agency and the Chemical Safety and Hazard Investigation Board. Thank you for inviting me to appear before you today. I would like to take this opportunity to publicly commend the Office of Inspector General's staff across the Federal Government who work hard each day to carry out our important mission. As the committee is aware, for more than a year, this OIG was confronted with a denial of access by the CSB. The CSB's leadership asserted that the denial was based on attorney-client privilege. We countered that such denial violated Section 6A1 of the Inspector General Act. With that impairment of my office's ability to provide oversight of the CSB continued, we resorted to the rarely invoked 7-day letter. This committee held a hearing on the 7-day letter and related issues on June 19th, at which you stated the CSB to turn over the documents to the OIG within a week. The CSB since has produced several sets of documents to the OIG. We've determined that the CSB has substantially, but not fully, complied with our document request. However, the evidence we have gathered demonstrates that there are additional documents within the scope of our request the CSB officials have not provided. In addition to the CSB matter, the EPA Office of Homeland Security continues to impede the investigations of this OIG. We provided testimony on that subject before this committee on May 7th. While there are multiple facets to this problem, the crux is this. The EPA asserts a belief that there is a category of activity defined as quote-unquote intelligence to which the OIG may have access only if the EPA determines the OIG access is permitted. This impairment by the EPA was ongoing when I arrived 4 years ago, and it is still not resolved. Now, I would like to discuss how well the IG Act is serving the taxpayers of this country in accomplishing goals that Congress set in passing it more than 35 years ago. On August 5th, I joined with 46 other IGs in sending a letter to this committee, as well as other congressional members, discussing the troubling pushback many of us have been experiencing from our respective agencies when we seek mandated access to employees and records. We asked Congress for a strong reaffirmation of the original and, we believe, still existing intent of the IG Act, that OIGs have unfettered access to all agency information to assist us in obtaining prompt and complete agency cooperation. Mr. Chairman, questions about whether the IG Act is accomplishing Congress's goals and whether the Act needs strengthening or clarification are not hypothetical to me. They are questions with real-world impact on my ability to carry out my mandated functions. You might think, therefore, that I would say without reservation that the IG Act requires some enhancements on access and agency cooperation. However, I want all of us, IGs and Congress included, to be very careful about what I am saying and what I am not saying on this issue. The Act, as written, is quite strong and quite clear. It provides access to all agency information and all agency employees. There are no exceptions, not for material that an agency asserts cannot be further released outside of the OIG once the OIG does receive it, and not for some piece of agency activity that might happen to involve classified information. No courts, no congressional committees, and no opinions from the Department of Justice's Office of Legal Counsel have given any cause for concern that the requirement for access to all information means anything other than all. Any attempt to clarify or strengthen that authority could only suggest that it is not already strong and fully encompassing. The IG Act hinges on the cooperation of an agency with its IG. If there is not prompt and complete cooperation, the work of the OIG is stifled. In this regard, the IG Act can be compared to a house of cards. If you pull out the agency cooperation card, the entire act collapses. I therefore urge this committee to look at enforcement mechanisms for the access and cooperation already required. The IG Act is fine as written. The agency's ability to ignore the Act without consequence is the problem. This OIG will be happy to work with your staff in concert with the Council of Inspector Generals on integrity and efficiency on solutions to address our access concerns. I believe that Congress can send a strong and needed message through legislative enhancements and other means that such impairment will not be tolerated. Mr. Chairman, this concludes my prepared statement, and I will be pleased to answer any questions you or the committee may have.
Thank you. And you yield back 4 seconds.
Yes, I will. Thank you.
Ms. Buller.
Chairman Issa, Ranking Member Cummings, distinguished members of the committee, thank you for inviting me to appear before you today and allowing me to summarize my prepared statement. You have asked me to testify about my office's difficulty in obtaining access to agency documents. I testified about this issue before your committee on January 15th, and while progress has been made, thanks in part to your efforts, some challenges remain. Our access issues stem from the Peace Corps' interpretation of the Kate Pusey Volunteer Protection Act of 2011, which Congress enacted after serious reports that the agency failed to adequately respond to volunteer victims of sexual assault. To enhance the Peace Corps' response to sexual assaults, the Kate Pusey Act mandates the creation of a restricted reporting mechanism so that volunteers may confidentially disclose the details of their assault and receive the services they need, without dissemination of their personally identifying information. Unfortunately, Peace Corps' General Counsel has written a legal opinion concluding the Kate Pusey Act overrides the IG Act, causing the agency to establish policies and procedures that deny OIG access to information. In the case of restricted reports, the agency argues the Kate Pusey Act prohibits the agency from disclosing to OIG any details of a sexual assault or the victim's PII. However, the Kate Pusey Act authorizes disclosure when required by law, and the law mandates an extensive oversight role to my office. In May, my office entered into a formal agreement with the agency to obtain some information from restricted reports. The agreement can be terminated by either party at any time, but we signed it so that we could get some information while continuing to seek agency or congressional action. Although the agreement improves our access, I am concerned about my office having to enter into an agreement to get information we are entitled to by law and that we need to do our job. I am also concerned that the agency's legal opinion authorizing it to withhold information from the OIG remains in place. This legal opinion sets a dangerous precedent whereby an agency may interpret a law as overriding the IG Act, forcing its IG to spend its limited resources and time wrangling with the agency to obtain information. Many have asked why we need full access to restricted reports. The answer is simple. Without full access, we cannot properly inform the agency or Congress whether the agency is complying with the Cape-Pusey Act and whether the agency's response to sexual assaults is getting better or worse. Furthermore, the Cape-Pusey Act mandates that my office conduct a case review of a statistically significant number of cases. Without full access to information, it's very difficult for us to complete this review and ensure that volunteers are receiving the services that they need. On August 5th, 47 IGs signed a letter to Congress expressing concern over our access issues, recognizing the implication of agencies refusing, restricting, or delaying IG access to agency documents. In response to inquiries about the letter, Peace Corps told the Washington Post it is, quote, committed to working with the Inspector General to ensure rigorous oversight while protecting the confidentiality and privacy of volunteers who are sexually assaulted, end quote, suggesting that privacy and oversight are mutually exclusive. They're not. My office is bound by the same confidentiality rules as the agency. It is trained and experienced in handling sensitive information, and there is no cited record of my office ever mishandling such information. The agency has also suggested that fewer volunteers would report sexual assaults if OIG had access to the information. But when pressed for a factual basis for this assertion, the agency had none. As the Daily Beast reported, quote, it's hard to imagine a case where volunteers decline to report sexual assault because the agency's internal watchdog will be provided information to determine there is no negligence or wrongdoing, end quote. The agency argues its policies and procedures are victim-centric. But what could be more victim-centric than providing independent oversight of victims' care? We ask that Congress reaffirm what is said in the IG Act. The IG Act, we also believe, is very plain on its face, and the legislative history also strengthens that intent. But there are individuals, like our General Counsel, who have taken it upon themselves to interpret another piece of legislation to override that act. We request that Congress and this committee take a look at reaffirming what the IG Act says and make sure everybody is on the same page. I thank you for asking me to testify before you, and I'm prepared to answer any questions.
Thank you. And you yielded back 12 seconds, so I've never had a more professional panel. I commend you all. We do a lot of hearings here that are partisan. As you know, this isn't one of them. So one of the challenges here is asking the first and most difficult question, which is, from each of your experiences, when did this begin and what do you think the source is? And I just, to the extent that you can say time and date and, if you will, accountable individual who you think is the decision maker or the impediment, I'd like that answer as succinctly as possible. Ms. Buller?
In my case, I think it's very easy to pinpoint the time and the person. The passage of the Cape-Pusey Act mandating the restricted reporting, I think, was the impetus. The person is the General Counsel. Basically, he has taken the opportunity to interpret the Cape-Pusey Act to impede our access.
Mr. Elkins?
In my case, I have two agencies that I oversee, the CSB and the Environmental Protection Agency. In both cases, I have to say that issues relative to access starts at the top, with a clear message from the top that access will be granted, it will be granted. To the extent that there is a muddled message or the message is not clear, you end up in situations that we have here today. Some of the, on the CSB side of the House, the issues started back in 2010, 2011. On the EPA side of the House, some of the issues that we're dealing with today actually started before I even came on board. So this has been an ongoing sort of matter. But to answer your question directly, it starts at the top. Clear message from the top, what the expectations are. That's the way the rest of the troops will march.
Thank you. Mr. Horowitz.
Our issues started in 2010, have continued. It started in 2010 with the FBI, raising objections. Other components have now joined in, and there's a long list of them that have said, me too, in terms of Section 6A of the Act doesn't mean what it says.
So what you're saying is it began with the FBI thinking they could beat your oversight, but like any infection, particularly a popular one, you're being shut out systematically.
Correct. If there's a way to do that, that's what happens.
Well, Mr. Horowitz, yesterday you and I were together over in Judiciary along with a number of the members, and I think you testified that on 6 occasions the Attorney General or the Deputy Attorney General has intervened when you've been denied and ultimately allowed you to get some of the information. Is that correct?
That's correct. Approximately 6.
Okay. So in your case, it's delay and impeding and, in fact, some of the benefits of an expedient investigation more than outright denial. Is that correct?
That's correct. It also compromises our independence.
Mr. Elkins, in your case, you continue, as I understand, in spite of the ranking member and his staff's efforts, to not get information, and that it is a decision being made by the agency head. Is that right?
Well, I can't say emphatically that it's coming from the agency head.
I should say the agency head has not intervened, and some of these letters ask her to do so. That's what I was saying in the case of EPA.
And I think that's a fair characterization.
Okay. But ultimately, that's the person who could intervene.
Oh, absolutely. Absolutely.
Ms. Buller, in your case, you cite the General Counsel, but the General Counsel is a referral point. There is an agency head that also has not intervened.
Yes.
And I think if I can take Mr. Elkins and Ms. Buller and bring your 2 statements together, which I think are important for Mr. Cummings and myself both. Mr. Elkins, you cautioned us not to attempt to clarify, if you will, and maybe come up short and diminish what already is the law. Well, Ms. Buller, you clearly said this review, which is also going on at Justice, begs the whole question of, is 6A, does it, notwithstanding other laws, mean what it says it means? Now, Mr. Elkins, I'm coming back to you for that reason. If either through executive action of the Office of the President or through congressional action, if we say, because we believe that notwithstanding other laws, 6A in the IG Act means what it says it means, does that both meet your test of not writing new law on top of already good law, but at the same time clarify the question so that there not be endless review by agency heads, general counsels, and referrals to legal review?
Yeah, I think that would be quite helpful. I think that message clearly, without any wiggle room in it, coming from the President would help. Absolutely.
Thank you. With that, I've used 12 seconds. I yield to the ranking member.
I want to go back to what the Chairman was just asking. So, Ms. Buller, as I listened to you and I read your testimony, and I thought about the issue here, the personally identifiable information, it just seems like we should be able to work that out some kind of way. I mean, have you gotten any further than the memorandum of understanding?
We have the memorandum of understanding in place, and we are hopeful that we can continue to do our work with that memorandum of understanding. But with the legal opinion that's still in place, if there's another dispute that comes up, regarding what PII is or what explicit details of the sexual assault is, we're going to be right back where we started, going back and forth with the General Counsel's office trying to figure that out.
So, Mr. Elkins, during your tenure as Inspector General, you work with the EPA to identify ways the agency can improve its management. For example, your office released 3 reports in the past month that identify ways the EPA can save money by improving its contracting processes and oversight. Is that right?
That is correct.
Your recommendations have led to many successful reforms. For example, on July 22, 2014, your office reported that the EPA implemented corrective action on all of your recommendations regarding EPA's nationwide monitoring system that protects us from exposure to radiation. Is that right?
That's correct, sir.
Congress has also charged you with overseeing the Chemical Safety Board, which I want to ask you about. You discussed in your testimony a long-term dispute with the CSB. You also identified before the committee in June, testified before the committee in June about that issue. Your office is investigating the use of personal email accounts by senior CSB officials to conduct official business. Is that right?
That is correct, sir.
On September 5, 2013, you sent a 7-day letter to the CSB seeking email records. The CSB refused to provide. This is the only 7-day letter you have issued in your tenure as Inspector General. Is that right?
That's correct.
And how long have you been Inspector General?
Over 4 years now.
After the committee's hearing, CSB provided some documents, but on July 8th, however, you informed the committee that CSB still had not fully complied with your request. You said the documents they provided were not fully responsive. The attachments were not provided, and some documents were redacted. Is that right?
That is correct.
More recently, CSB has provided additional documents, including unredacted copies. And on September 8, 2014, you sent a letter to the committee saying, and I quote, "OIG concludes that the CSB has substantially complied with our document requests. However, the evidence we have gathered demonstrates that there are additional documents within the scope of our requests which CSB officials have not provided to the OIG," end of quote. So it sounds like the CSB improved its cooperation following the committee's hearing in June, but even that was like pulling teeth. Is that a fair statement?
That's a very fair statement.
Well, I got to tell you, I think that this is totally unacceptable. Can you tell us now specifically how you know the CSB is withholding documents?
Well, I'd like to think I've got a crack team of investigators that ask good questions, and we track the documents, we track the questions, and I mean it's really just matching it up. We ask certain questions, we take a look to see if we've got a response, and if the response is not there, then there's a void, and that's pretty much what we've got.
Can you identify the categories of documents that you believe that are being withheld for the record so that we can follow up directly?
Yeah, I can give you somewhat of a characterization. For instance, there was, of course, the instance of using, email that's not government email to conduct agency business. At one point in the process, it was conveyed to us that there was a directive to CSB staff not to do that. And then subsequent, we found emails that suggested that after that date, it was still going on. So in our mind, that suggests that there's a disconnect there. So that's one example.
Just last question. In the letter you sent on Tuesday, you said you will be issuing a report of investigation in the near future. What will the scope of that report be, and when do you expect to issue it?
Well, it will be a compilation of what we have determined, based on the facts of the case. At this point, it appears to us that that the CSB leadership was using means other than federal communication means to conduct agency business. So that's where the report is likely to head. In terms of when that report is going to be issued, I can't give you an exact date, but I would say very shortly, maybe within the next 90 days or so.
All right, thank you very much, and we will follow up.
Would the Ranking
Yeah.
Member yield? Just to clarify, Ms. Buller, did you ever ask on this personally identifiable information and the details of these sexual assaults, did you ever ask for in-camera review for your people to look at the documents without receiving them?
No, that wouldn't have been permitted under the General Counsel's legal opinion.
But the question is, did you ask? Did you
No.
attempt to have something where you would respect the fact that you wouldn't take possession, but you at least would review them?
No, we did not.
Just one last
Of
question
course.
to follow up. You know, as I listen to your testimony, one of the key, when I think about the conflict, and you said that your agency has been used to handling very sensitive information and keeping it confidential. I'm sure you made those same arguments to the Peace Corps.
Yes.
And what was the response? I mean, because we've got government, public servants who want to do the right thing, and the last thing your agency would be doing would be going against yourself by revealing information, identifying somebody who may have been sexually assaulted. So I'm just wondering what happened there? And you follow me? Is it that they don't, you think that there's a distrust, or?
The way that the Cape-Pusey Act is drafted, there are two exceptions on the disclosure. One is for one of the exceptions that is enumerated, and the other is that if the person files a restricted report, it won't automatically trigger an investigative process. Our General Counsel basically interpreted the receipt by my office of any information from a restricted report as doing that, automatically triggering an investigative process, even though we assured him that we are required to follow the law, that if we got any restricted reported information, we would not use it to trigger an investigation. It didn't seem to make an impact on him. And he is the only person who has concluded that the two laws conflict. When you read the two laws, there's a way to interpret them that they don't.
Very well. Thank you very much.
Thank you. Mr. Mica.
Thank you, Mr. Chairman, and thank you for holding this hearing, and I appreciate the Inspector General's testifying. I guess with being the senior member of the committee and having gone through almost all the half a dozen or so chairmen and hundreds of members who've been on the panel, you get a little bit of institutional insight. I have never seen an instance in my 21-plus years of 47 Inspector Generals coming together and saying that their oversight was being obstructed. Mr. Horowitz, do you know of any instance similar to this?
I don't.
Mr. Elkins?
This is the first in my recollection.
Ms. Buller?
I don't recall any either.
Each of the instances which you've come here to cite before us have different parameters. Some of them, you know, there could be questions, and I've seen some of your recommendations for possible changes in legislation, and that would be one way to resolve some of the issues. I think, Mr. Horowitz, you have some recommendations about some exemptions that are currently allowed that should be excluded. I think you, Ms. Buller, is that correct? Yes. Just answer yes,
Yes.
Ms. Buller. Yeah, okay. Mr. Elkins, with the EPA, it appears that the action taken by EPA in really ignoring you and allowing whistleblowers and others to be intimidated, this has undermined your position as Inspector General to conduct your legitimate investigative oversight responsibilities. Would that be a fair statement?
Yeah, that would be a fair statement.
The other thing that would concern me is using some language or exceptions that are in the law and the case of justice and the Peace Corps to obstruct investigation, or even worse, to cover up. Particularly concerned about the sexual abuse instances. Now, some of these cases, the staff had told me, maybe like Peace Corps worker on Peace Corps worker, or some locals on Peace Corps volunteers. Is that the case?
Yes.
And again, it appears that it is a sort of a blatant cover-up of sexual abuse cases that some might embarrass the agency. I guess you expose yourself when you send people to foreign lands or on any mission to locals or foreign nationals taking advantage of American personnel. But I think how prevalent is the case of problems with Peace Corps workers being involved in these instances?
Usually it's a host country national involved in the assaults. From what we gathered, the information we gathered, it's usually volunteer on volunteer or staff on volunteer in about 4% of the cases.
And how many?
About 4% of the
4%. Not huge, but it's very embarrassing, I would imagine, to the agency. And, you know, again, I think we have a particular position of responsibility to deal with that kind of action. And also, I think you should have that authority to uncover, again, what's going on and expose it. A couple of questions, because the Inspector Generals have been under attack for a number of years now. Several ways of attacking them. One, get rid of them. We went through that in the beginning. I remember Gerald Walpin, and he was removed. I think the committee let it be known that that was not going to be tolerated, although they did get away with that, that particular instance. Then not appointing attorney generals. I'm told there is it 13 vacancies, 7 presidentially appointed, about 15–20% of the Inspector General positions are vacant. Is that about right, Mr. Horwitz? Yeah.
I think that's
Do you
right.
think, Mr. Elkins?
I don't have the statistics.
You're not, okay.
It sounds
Well, again, these are the numbers that I have. So you don't appoint them, you try to get rid of them, and then you don't cooperate with them and obstruct them. And those are all very serious problems. But appreciate, Mr. Chairman, you're bringing this matter to the attention of the committee.
And I thank you, Mr.
Further
Mica.
questions later on. Thank you.
And the gentleman yields back. We now go to the gentleman from Virginia, Mr. Connolly.
Thank you, Mr. Chairman, and thank you for holding this hearing. I find myself in firm agreement with yourself and with the ranking member in your opening statements. Ms. Buller, in my other committee, in the House Foreign Affairs Committee, we actually, Judge Poe and I had some legislation dealing with the Peace Corps and the whole issue of sexual assaults and how best to handle that. There were a series of investigations and investigative stories really that were highlighted how poorly, historically, the Peace Corps had heretofore frankly managed cases of sexual assault among volunteers. We introduced legislation to try to address that. And so I'm particularly concerned to find that today on this subject at the Peace Corps, there isn't full cooperation with your office. So that's the context in which I look at particularly the Peace Corps issue and the role of the IG. In January, you testified before this committee and raised concerns about access to Peace Corps information. Is that correct?
yes.
And what was the nature of that testimony?
It was the same issue.
Could you speak into the microphone? Thanks so much.
It was the same issue that I'm testifying about today. It's the lack of access to restricted reported information.
Specifically, in 2011, we passed the Kate Pusey Volunteer Protection Act, to which I just referred, requiring the Peace Corps to establish a restricted reporting system giving volunteers the option to report sexual assaults on a confidential basis. Under the Pusey Act, the Peace Corps IG is required to conduct a case review of a statistically significant number of sexual assault cases to evaluate the effectiveness of that policy and to provide a report to Congress. Is that true?
Yes.
Due to the Peace Corps' interpretation of that act, the agency, however, withheld from the IG certain personal information about victims as well as sexually explicit details about sexual crimes. Is that correct?
Yes.
On May 22nd, you and the agency signed a memorandum of understanding. Under that agreement, the agency agreed to provide you with access to all information related to restricted reports other than clearly defined personally identifiable information and explicit details of sexual assaults. Is that correct?
Yes.
Since that MOU has been in effect, has your office requested any sexual assault case information under the MOU from the Peace Corps agency?
We have requested crime incident reports for a program evaluation that we were going to do.
Did you say 5?
No, 2. Well,
2.
we had 1 program evaluation, and we requested all of the crime incident reports, including restricted reports for that country before we went into evaluation. There were 2 reports. We did get both reports with the redactions.
So with the appropriate redactions?
Yes.
From your point of view?
According to the MOU, yes.
Right. So since that MOU has been put into effect, you have had requests and you have found full compliance on behalf of the agency?
Yes.
Is it your expectation that the case information that you did receive is useful to the work you're undertaking?
It's useful to the particular program evaluation we're doing at this particular point in time. The problem that we have is when we are going to do our case review for the Pusey mandated work, it requires a statistic sampling to do that. And the Peace Corps has no case management system so that everything is compiled in one place. We have records in medical, we have records in the Victim Advocate Office, we have records all over the place. And we don't have any way to track how a volunteer is treated after they've been assaulted because there's no case management system.
Even now?
Even now, yes.
And would that case management rubric also include legal actions? So, for example, if somebody's been sexually assaulted, presumably there's a legal case pending in the host country.
If there is, it should be included in the records, yes.
But it's part of the case management problem, I assume. That's also somewhere else.
If the case was actually taken into court, it would no longer be a restricted report, so we should have access to that information anyway.
And do you?
Yes, we do have access to non-restricted reports. The problem is the default position for Peace Corps is every report of sexual assault that's filed is automatically restricted until a volunteer determines to make it otherwise. So the universe of restricted reports is quite large.
Thank you. Mr. Chairman, I just want to end by saying this is a particularly troubling case since Congress, on a bipartisan basis, actually addressed this topic, the Peace Corps and the incidence and management of sexual assaults of volunteers abroad. And to find 3 years after passing that act that we're still finding problems internally with the Peace Corps that directly affect the victims because their cases aren't being managed efficiently and properly and sympathetically, and the IG has not had until the MOU full cooperation from the agency, is troubling indeed. And to me, circumvents the letter as well as the spirit of the law Congress passed to try to address this very sensitive but real issue affecting our Peace Corps volunteers. Thank you, Mr. Chairman.
Your comments. I now turn and recognize the gentleman from Utah, Mr. Chaffetz.
I thank the Chairman, and thank you, the 3 of you, for being here. You play a vital role in the checks and balances and just good government, and I thank you for your time and your dedication for you and your staff. I'd ask unanimous consent to enter into the record the letter dated August 5th, 2014. This is a letter to Chairman Issa, Ranking Member Cummings, Senators Carper and Coburn from the 47 IGs.
Hearing no objection, it will be entered.
I want to read just 3 sentences from this letter. The undersigned Federal Inspectors General write regarding the serious limitations on access to records that have recently impeded the work of Inspectors General at the Peace Corps, the Environmental Protection Agency, and the Department of Justice. On page 2, last paragraph, moreover, the issues facing the DOJ OIG, the EPA OIG, and the Peace Corps OIG are not unique. Other Inspectors General have, from time to time, faced similar obstacles in the work, whether on a claim that some other law or principle trumped the clear mandate of the IG Act or by the agency's imposition of unnecessarily burdensome administrative conditions on access. It is extraordinary that 47 Inspectors General have issued this letter expressing this concern, but I would also like to ask unanimous consent to enter into the record a letter from the Director of the Office of Management and Budget dated September 9th, 2014.
Without objection, be entered.
Let me read a sentence here from that response from the Director of the OMB, and then I would like each of you to please respond to it, because the Administration doesn't seem to think there is a problem. In this letter, paragraph 3, the last sentence says, overall, the numbers reported by the IGs demonstrate that Federal departments and agencies in this Administration value the work of IG offices and are almost uniformly successful in getting them the information they need to perform their responsibilities, end quote. This letter, if you were to read this letter, the Office of Management and Budget issuing a letter a full month after the 47 IGs, they don't think there is a problem. How do you respond to that sentence? We'll start with Mr. Horowitz.
I can only speak from experience and what I have heard from other IGs, which is we have faced roadblocks in several of our reviews, untimely access, where we have gotten it. It has taken a fair amount of time. I think the other IGs have had their experiences, and I know from conversations with fellow IGs, while they haven't had lawyers come forward and say, we can't legally give it to you, they have had issues with getting materials in a timely manner. That is a very significant issue for us.
So when it says almost uniformly successful, how would you characterize what you are able to access and get right now, particularly from the FBI?
It has been an extraordinarily difficult issue for us for now several years to get prompt, timely access to materials.
Mr. Elkins?
I think there is a disconnect, and I think that statement that you just read capsulizes the disconnect. On the one hand, I think what we have seen here is that, we hear from time to time that, well, there is substantial cooperation with the OIG. I mean, 80%, 90% of the time, there's no problems, you get what you ask for. But that assumes that the other 10 to 20% of the time that we're not getting what we asked for is okay. And that suggests that it's a moving target. And that's a very slippery slope. And that is exactly, I think, why we're here today in talking about these issues, because there's this assumption that most of the time we cooperate. And that's where the focus is at. But the real issue here is, what about that 10% of the time that there is no cooperation? And that seems to just keep jumping around and jumping around. That's the problem. And I think that message says that it's a broad problem with OMB and in a lot of agencies.
Thank you, Mr. Elkins. Ms. Buehler.
I agree with my esteemed colleague. From our perspective, we've had an agency issue opinions or issue policies and procedures specifically stating that we can't have access to something. So it's very difficult for me to understand how it's not a problem. And I think the fact that 47 other IGs have at one time or another, maybe not all the time, but one time or another had problems, should be an indicator that there is a problem.
Well, thank you. I, again, appreciate the great work that we do and look forward to hearing from you further. Yield back.
I thank the gentleman, and now I recognize the gentleman from Pennsylvania, Mr. Cartwright.
Thank you, Mr. Chairman. And thank you for the Inspectors General appearing here today. As this committee has previously highlighted, the offices of Inspectors General are essential to the efficiency of our Federal Government. They help hold agencies accountable, identifying misconduct in programs and by personnel. They can highlight the holy trinity of waste, fraud, and abuse, guaranteeing that American taxpayers get the most bang for their buck. The position of IG is a difficult position to hold, and IGs are tasked with investigating alleged abuses among those with whom they work. Of course, however, a balance has to be struck between confidentiality and privacy rights of victims, as well as whistleblowers, and the needs of the Inspectors General. Ms. Buller, I listened to your testimony closely, and also your questioning by Representative Connolly. As you noted in your written testimony, the OIG recently reached this Memorandum of Understanding with the Peace Corps on how best to comply with the K-PUSY Peace Corps Volunteer Protection Act. Obviously, many victims of sexual abuse and assault choose to report that conduct anonymously out of fear of retribution and for their safety in general. And there's an irony, isn't there, in that the K-PUSY Act was intended to provide tighter oversight to make sure complainants' anonymity is protected. In fact, K-PUSY herself was murdered by her attacker when the Peace Corps mishandled her complaint and her identity got out. And I think Mr. Connolly has made that point. But there's this irony that the K-PUSY Act was intended to tighten oversight of the confidentiality, and at the same time now we hear that the Peace Corps is saying that because of the need for confidentiality, they don't want to cooperate as much with the OIG. And I see that, and I think probably a good thing to do this morning, Ms. Buller, would be for you to elaborate. You touched on it briefly in your testimony about how professional your staff is and how careful you are with anonymity. Will you elaborate further and tell us more about systems and procedures in place to protect anonymity?
Sure. All of my staff is required, as is Peace Corps staff, to comply with all of the laws that protect personal identifying information, such as the Privacy Act, HIPAA, things of that nature. We are all required by law to comply with those the same way that Peace Corps staff is. Furthermore, my investigators are trained investigators. We must comply with all of the guidelines from the Attorney General. We have full law enforcement authority. We participate like any other law enforcement organization. And my evaluators, when they go out to a post, they go to the volunteer sites and sit and interview individual volunteers, and they tell them that they will not use their name because they're trying to find out how well Peace Corps is actually supporting those volunteers. So they do not use their names. They aggregate information and bring it back so that we can issue a report to the agency to tell them that you have these problems in this area, that volunteers don't feel supported in another area, things of that nature. We are a very professional staff, and we do comply with all of the federally mandated laws.
I thank you for that. And you did say in your testimony there's never been an instance of the Office of Attorney General being implicated in an improper disclosure of an identity. Is that correct?
Yes.
And there never will be, will there?
No, there will not.
Well, I thank you for testifying here today, and we take your testimony seriously.
Thank you.
Mr. Chairman, I yield back.
I thank the gentleman, and before I recognize myself for 5 minutes of questioning, I would ask that an additional document that follows up the preceding documents, a letter addressed to the Director of Office Management and Budget on these issues and signed by our Chairman and Ranking Member, as well as the corresponding Chairman and Ranking Member of the Senate, be introduced into the record. Without objection, it will be introduced. I thank the witnesses for being here as well and carrying on with this continued investigation to make sure that your work is accomplished. Mr. Horowitz, I still remember our first meeting in my office when you came in after after your appointment, and how direct you were about saying, my job is to be the job that the OIG is supposed to do, and to get to the bottom of the issue regardless of where we find ourselves, and I appreciate that. Let me ask you a question relative to a fairly high-profile investigation that we've been involved with, as well as you. Were there restrictions or limitations on your ability to access documents in your investigation into the Operation Fast and Furious?
That's one of them, the investigations where the issue was first raised back in 2011 to our access.
Did you have to make document requests in writing?
We did, and the issues came up both in the context of our request for grand jury information, which, as you know, given the case was a criminal case, were many, as well as wiretap information, as you know from our report, there were many.
How long did it take for you to get access to those documents?
It took many months for this issue to be resolved, and it was resolved through an order being issued by the leadership, not through our independent access pursuant to the IG Act.
Elaborate on that last statement a little.
Yes. In our view, we have a right, as Congress has laid out in the IG Act in Section 6A, to get the materials we ask for. When we ask for materials, we ask for relevant information, responsive information, and in our view, we're entitled to that. By law, Congress has been clear. The FBI, other components in the Department, have taken the view that the IG Act perhaps doesn't mean that. Indeed, we've been told that that was the Office of Legal Counsel's preliminary view, that it wasn't sure the IG Act meant what it said. And as a result, it required an order of the Attorney General or the Deputy Attorney General to the component that said, I find these reviews are of assistance to me as the leadership of the Department, and therefore you can give the IG those materials.
How has the requirement that the OIG obtain written permission to access documents related to the Fast and Furious operation affected your office's ability to conduct a complete investigation in the matter?
It delays, it frequently has the impact of delaying our reviews, not only because we have to go through that process to the leadership of the Department, but also because, frankly, it encourages other objections by other components of other issues. For example, personally identifiable information that IG Buller has talked about. That issue was thrown up in front of one of our reviews on sexual misconduct within the Department by both the FBI and the DEA. That's a frivolous objection, and after many months of back and forth was withdrawn by the agencies, and we finally got the material.
How does all of this affect your independence?
It compromises it, in my view, entirely. I should not have to go to the people I oversee for approval to get records. Congress, I don't think, intended that. That would undercut in every way our independence.
We certainly didn't. I appreciate that. Let me ask questions of each of the panelists. Other than the reason described in the letter from 47 IGs, what tactics do agencies use to deny OIGs access to agency records and documents? And Ms. Buehler, I'll start with you.
In my case, we've had instances where our situation and the issue on the Cape Pusey Act has bled into other areas. For example, they redid the case or crime reporting management system for standard reports, and when they did that, we were denied access to that for no reason, because they were not restricted report. So we had to go back to the General Counsel, and actually I had to go to the Director of the agency and make a personal plea to get the information that we had been getting all along reinstated to us. It just, once you start down the road where there's preventing you from getting information, it pops up in different places and unexpected places.
Mr. Elkins?
In my case, what I see is stonewalling, to a large extent, parsing out information. You ask for 10 pieces of information, and you get 2 or 3 pieces of information, and then there wants to be a discussion on the other 7 pieces of information, and then there's continually fighting and going back and meetings, and at the end of the day, a year later, you still don't have the information, and in the back of my mind, what I hear is cha-ching, cha-ching, cha-ching. That's the taxpayers' dollars that are going out and being used on the agency side and on my shop side to be able to solve an issue that the IG access, when we ask for information, we're supposed to get it immediately and promptly, and if we had received it at that time, the cash register wouldn't continually be ringing. So that's what I say.
Mr. Horowitz.
As a result of the position that the IG Act may not mean what it says, the FBI has put in place, in our instance, their general counsel reviewing all of the materials and all of our requests for materials before they come to us. That requires reviews by lawyers at the FBI. It delays us getting access. And a concrete example of what that means, in a review we are doing, we asked one of the subcomponents within the FBI for an organizational chart. They told us they couldn't give it directly to us because of the standing requirement within the FBI that materials have to go through the Office of General Counsel first. And so we were delayed for weeks in even getting an organizational chart so we could figure out who to talk to in the course of a review. That should not be happening. That is a waste of money, as IG Elkins just said. We have entitlement to the access to the records. I'm not sure what use there is of the resources of the FBI to go page by page through records before giving it to us.
Thank you. My time has expired. Now I recognize the gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. The Inspector General community plays a key role in making the government more honest, efficient, and effective in ensuring wise stewardship of taxpayer money. I have seen firsthand their work, and obstruction of their work is simply not acceptable. So I take the concerns being aired here today very seriously, and hopefully the message that my colleagues and I are sending on this point today is heard loud and clear. I'd like to discuss the concerns I have with EPA's Office of Homeland Security in particular, and Mr. Elkins. On May 7th of this year, the Assistant Inspector General for Investigations at EPA testified before the committee and raised a number of access concerns. Specifically, Mr. Sullivan expressed frustrations that the EPA's Office of Homeland Security, OHS, was denying access to important classified threat material that was impeding your ability to investigate threats against EPA facilities and its employees. He also testified that OHS refused to share misconduct cases with his office because OHS believed it was, quote, a de facto law enforcement organization in itself. And finally, Mr. Sullivan raised concerns that OHS did not recognize the IG's statutory authority over intrusions into EPA's computer networks, apparently denying access to classified information related to possible cyber intrusions. Is that a fair summary of your concerns also with the OHS office under EPA?
Yes, ma'am, that is a fair characterization.
Thank you. So I understand from your testimony today that you continue to have problems with access to information from OHS. Is that correct?
Yes, ma'am, that's correct.
In June 19th of this year, EPA Administrator McCarthy sent you a memo entitled Working Effectively and Cooperatively. That's correct. Is that correct?
I don't recall that exact memo. June 19th, you say?
It's called Working Effectively and Cooperatively.
Oh, yes, I do recall that, yes.
Okay. So my understanding is it attempts to construct a framework for better cooperation between OHS and your office, and Section 5 of the memo lays out a dispute resolution process. Has that process been used by your office since receiving the memo?
Well, I can speak from my own personal opinion. No. I mean, we still have the same issues that we had at the date of that letter. So if there was a dispute process that was used, it hasn't worked, and I haven't been a part of it.
Okay. Do you think it should and it could or should be further enhanced at the dispute resolution process, or do you think that that is something that's just hindering your work in general?
Well, personally, I think, the IG Act says all means all. I mean, when we ask for information and access to documents and individuals, that's exactly what it means. Entering into a dispute resolution process sends the message that there's some wiggle room, that it can be negotiated, and I'm totally against that process.
So the committee staff attempted to assist you in resolving this impasse that you're having with EPA's Office of Homeland Security. My understanding from your testimony and what you just said, that we're still hitting roadblocks. Is that correct?
Absolutely.
What steps do you think would be helpful to resolve some of the disputes that you're having, and how can this committee be helpful to you in that process?
Well, I think ultimately the administrator needs to send a clear message that the IG Act requires absolute cooperation with the IG. If that message is sent, I think everything would change. And until we get some clear message from the administrator to that effect, I think the status quo will continue.
Do you think the inspector is supporting OHS's position that they are a de facto law enforcement agency within the EPA?
I'm sorry, can you repeat the question, please?
Do you think that the Administrator McCarthy's position, or from what he has said, with this, by supporting this memo, working effectively and cooperatively, and not sending out this, the statement that you should have full access, do you think that he supports what OHS believes, that they are a de facto law enforcement organization within EPA?
Well, I don't want to put words in the administrator's mouth, but the end result is that the status quo continues. So I can only infer that the administrator agrees with that.
Okay. Thank you. Thank you so much, Mr. Chairman, for having this hearing. To the extent that this committee and its staff can be of assistance to help address this impasse, we certainly should be willing to help. And again, Mr. Elkins, thank you for the work that you do for us and for the American taxpayer.
Thank you, ma'am.
I yield back, Mr. Chairman.
Thank the gentlelady, and now I recognize the gentleman from Oklahoma, Mr. Langford.
Thank you, Mr. Chairman. Thank you all for being here and for your work that you do every single day for the American taxpayer. We really do appreciate it. What the Office of Inspector General does in every one of these agencies is extremely important. Congress and the American people established all of these agencies. These agencies just didn't appear out of dust and one day have responsibility. Congress created these agencies, and then Congress has the oversight responsibilities for these. What the Office of Inspector General does is to bring transparency to the American taxpayer, and so what you're doing is vital. So with that, Mr. Horowitz, if I asked to see all of the papers on your desk, would you assume that's only 3 pages, or would you assume that's all?
I would assume it's everything.
Would you assume if I asked for all the pages on your desk that you could go back and seek counsel and then come back and say, no, we've really decided all doesn't mean all?
Pursuant to the IG Act, no, you would get everything.
Okay, I have a real issue when any agency steps in and says, I know Congress has required all these pages to be turned over, but we've discussed it as an agency and we're not going to turn it over. I have an issue with that. I have an issue with any time an agency steps up and says, we don't like some of the information coming out, and so we're going to choose not to give it. I don't like it when I read reports from the Attorney General when he writes back to the Inspector General and says, I have determined that providing the OIG with access to it is helpful to me, and so I'm going to turn this over because it's helpful to me. That implies to me that he's also reviewing other documents and saying, I'm determined this is not helpful to me, so I'm not turning it over. That is not the responsibility of the Attorney General of the United States to be able to conceal documents that are not helpful and to turn over documents that are. So with that, I have several questions. The roadblocks that you all have experienced over the last several years. Mr. Horowitz, you've been at this how many years?
A little over 2 years.
So of what you have seen, and the folks that you have talked to, Mr. Elkins, how long have you been at this as an Inspector General or with the Inspector General's office?
Just a little over 4 years, sir.
Okay. Ms. Buehler?
6 years.
Okay. The question is, this is obviously an old law. This is not new. This is requiring the administration, every administration, any administration, to say American tax dollars are used here. What have you seen in the individuals that you have talked to and other folks that have around that have worked in the Inspector General office, some for decades? What are they experiencing now that has changed? And has it changed? Is this just normal protocol from every administration to drag their feet on every investigation, or is something changing? And I'm not asking this in a political way. I'm just trying to figure out, is this just typical normal protocol from every administration, every agency?
I can certainly speak to our situation. I've talked to my predecessors, and I think the answer is quite clearly no in our circumstances. We did FBI oversight after the attacks of 9/11, after the Robert Hansen scandal. We were given complete access to the materials we needed. We didn't face these kinds of issues. Frankly, we didn't face these issues until 2010 or 2011.
Are you finding that FOIA requests and the information coming out from a FOIA request is coming out as fast or at equal speed than what you are getting from the Inspector General's office?
I actually haven't compared those, so I couldn't speak to that.
I can tell you in Congress we are finding that. that at times that we'll make a request of a document and a FOIA request happens, and the FOIA request gets it the same day that we do, sometimes faster. So that has been an issue. Mr. Elkins, I have a question for you. You're dealing with the EPA, and you said in your oral testimony that you're being blocked from the EPA receiving information that they have deemed intelligence activity. Tell me about that.
Yes, sir. The EPA, the Office of Homeland Security, has asserted that it is the primary office in EPA to handle any issues related that have intelligence connected to it. Unfortunately, they do not have investigation authority. There's only two entities within EPA that has investigative authorities. One is the OIG and the other is CID. In terms of employee misconduct cases, which typically result in where you have intelligence information where individuals inside the agency is doing something illegal, it's going to be related to employee misconduct.
Right. So can you tell what intelligence activity is within the EPA? What they're saying they're withholding this information from you. You can't look at it because it's intelligence activities. Can you tell what that is?
Well, to the extent that they have the intelligence activities information, I don't know because they don't share that information with me.
Well, I can tell you this committee finds that ironic because it wasn't that long ago we had someone sitting at that same table that pretended to be with the CIA and was also with the EPA, and for years eluded EPA oversight because he claimed he was secretly working for the CIA. So I find it ironic that the EPA is now telling the Inspector General, well, this is intelligence related. We can't pass this on for oversight. I'm going to be very interested to hear from the EPA what intelligence activities that they are doing on the American people and what intelligence activities that they're doing nationwide or worldwide related to the Environmental Protection Act, and why they would say this is so secret that we're not going to allow the American people to see the activities of the EPA or to allow the Inspector General to participate in oversight for that. I think that's a reasonable question to ask any agency that doesn't have investigative intelligence responsibilities, how they have somehow created their own intelligence department and what they're doing with that. Mr. Chairman, thank you for allowing me the extra seconds here of questioning, and I thank you all for your work.
I thank the gentleman, and I recognize the gentleman from Nevada, Mr. Horsford.
Thank you, Mr. Chairman. I appreciate very much this hearing, and we started off saying that this was going to be nonpartisan, and unfortunately, as usual, it turns into a bit more partisan than it should, because the role that the IG plays is very important. Your mission is important, and we should be working in a nonpartisan fashion to support that. Mr. Horowitz, I do want to follow up on your comments by my good friend the gentleman from Oklahoma, and to ask you to clarify a little bit based on your testimony today and your previous testimony in January. I want to ask you about some of the concerns that you raised regarding your office's access to categories of information relevant to ongoing IG reviews, including wiretap and grand jury materials and documents related to the Department of Justice's use of material witness warrants. Mr. Horowitz, as I understand it, in specific instances, you have had to seek access to this information from the Department's leadership, correct?
That's correct.
When testifying about this same issue before the committee on January 15th, you stated, and I quote, "In each instance, the Attorney General or the Deputy Attorney General provided us with the permission to receive the materials." Is that correct?
That's correct.
You also wrote in your testimony today that the Department has informed you that, quote, "it is their intent to continue to grant permission to access records in future audits and reviews." Is that correct?
That's correct.
So, Mr. Horowitz, as a preliminary matter, has all of the information you have sought from the Department been provided to you?
We are told that it has been.
Has any information that you have requested from the Department ultimately been withheld from you?
Ultimately, no. We've gotten it after many months.
So during the January hearing, you testified that your office's access issues were, quote, "not necessarily specific to this Attorney General, this Deputy Attorney General. It is an issue that my predecessors have had to deal with." Is that correct?
It is correct that they've had to deal with timely production of material.
So when you were asked by my good friend, the gentleman from Oklahoma, is this an issue that is unique to this department's leadership, that was not the answer you just gave.
The issue arose in 2010 when my predecessor was still there and continued beyond that. There were other issues that predated in terms of timeliness, but we have not had a legal objection raised by a component until then.
I appreciate that clarification. It is my understanding that the Department recently requested a formal opinion from the Office of Legal Counsel to resolve a conflict between the interpretation of Section 6A of the IG Act, which grants the IG prompt and full access to all necessary requested information, and several statutes that restrict the release of certain types of protected information, such as a grand jury and wiretap material. It is also my understanding that the Department has told you that it is committed to working with you to provide access to all materials necessary for your office to complete its review until the OLC releases its opinion. Is this correct? Is this a correct understanding?
As I made clear in my testimony, the leadership has made that clear. The problem is every day this goes on without a decision, we're not independent. We're not acting in an
But that is not an issue of the leadership of that department.
Right. As I testified today, the leadership has made it clear they will continue to issue orders to the components to get us the records, but the issue is whether that's really required by Congress's act.
And so therefore, Chairman, I think to the degree there's some clarification, it's the clarification within the disputes with Section 6A and the statutes, not as some will like to assert, somehow the Department's leadership in a lack of providing information that's being requested of them. And I just think that that needs to be made clear for the record. I'm encouraged the Department's leadership has been working to provide your office with access to the information it needs to do your job, including grand jury and wiretap information that must be closely guarded. And I hope that both parties continue to work together as we move forward on this important issue. Thank you very much, Mr. Chairman. I yield back my time.
I thank the gentleman, and I guess I would express my pleasure at this hearing so far, up until now, that it has been bipartisan, nonpartisan, looking for answers of what is happening now so that we can move forward and do it right. And so I would state that I think that is what this committee hearing has developed around and over and has been carried on. So I appreciate the bipartisan fashion and the nonpartisan fashion so far. Having said that, let me recognize, looking at the list here, Mr. Duncan from Tennessee.
Well, thank you, Mr. Chairman. I'm sorry I had to preside over the House, and so I couldn't hear all of your testimony. But I introduced the original bill to create an Inspector General for the Tennessee Valley Authority, and I've always believed very strongly in the Inspector General process, and it's been very, very helpful to the work of this committee. But I was really amazed by the number of Inspectors General that signed this letter. I'm told it was, I haven't tried to count them, but I'm told it was 47, I think, or something like that. That's pretty amazing. I think that certainly is not something that we've ever seen before. So apparently there's pretty serious concern by people who are in the know, so to speak. Mr. Horowitz, I understand, though, that there are several high-profile investigations, such as in the new Black Panther case and the prosecution of the late Senator Ted Stevens and the torture memo case, other matters where your investigation has been hindered or delayed or something by the Office of Professional Responsibility. could you tell me about that and explain a little bit about what that's done to your work?
Yeah, certainly, Congressman. The issue there is that when Congress set up our IG office in 1988, we weren't part of the original IG Act. It kept in place the Office of Professional Responsibility, and it provided that, unlike with regard to all the other employees in the Justice Department, that we don't have jurisdiction to review alleged misconduct by Department attorneys. So as a result, matters such as those cases go to the Office of Professional Responsibility, which lacks statutory independence, instead of coming to us. So we actually have no authority to investigate those matters.
Well, I understand that, but what I'm asking, there have been these high-profile situations, and I'm sure several much lower-profile cases where there has been misconduct by Department of Justice lawyers. Do you think that your office would be capable of investigating this type of misconduct along with the Office of Professional Responsibility?
We absolutely think that, and I think we've demonstrated that, frankly, by issuing reports regarding agent misconduct, such as some of the work we've done in the FBI context. We've demonstrated quite ably our abilities to do that, and I think the same independence that Congress believes is important over the independent oversight over the FBI should also exist with regard to Department attorneys.
I'll ask the panel as a whole, do you feel that there's been a overclassification of documents by the departments or agencies with which you've worked, or in which you've worked, or in other departments that you've read or heard about?
I have to concur with Mr. Horowitz here. Yes, I have heard that. In my particular agency, that has not been an issue particularly, but I have heard that issue raised, yes.
Peace Corps doesn't have original classification authority, so that's really not an issue at the Peace Corps.
We have found some issues related to that in one of the reports we did last year and have reported out on that.
All right. Well, thank you very much, Mr. Chairman.
I thank the gentleman, and the Chair recognizes the gentleman from Illinois, Mr. Davis.
Thank you very much, Mr. Chairman. And let me begin by emphasizing how much I value the work of the Inspector General's community in helping our government function better and become more efficient. So I want to thank all of you for being here. It is imperative that all Inspectors General have a good working relationship with the agencies they are tasked with overseeing in order to fulfill their mission of identifying and eliminating waste, fraud, and abuse in the Federal Government. Mr. Horowitz, I would like to ask about the Department's overall level of cooperation with your office. You testified before the committee on January 15th of this year that, and I quote, "Most of our audits and reviews are conducted with full and timely cooperation from the Department's components," end of quotation. Is that a correct?
That's correct. In most of our work, we had full cooperation.
Would it be fair to say that the access concerns you raised in your testimony are limited to specific instances and not representative of a larger scale agency-wide problem?
I would say there are limited reviews where we've had this problem. The problem, though, is, as IG Elkins and IG Buller said, it takes on a life of its own. We get what I think are, frankly, frivolous objections in other instances that don't have to go to the Deputy Attorney General or the Attorney General, because I'm able to work them out with agency leadership at the DEA or the FBI or wherever it is. But these problems, once some people see they can object, you get more and more objections, frankly.
Thank you. Your office's semiannual report to Congress for the October 2013 through March 2014 reporting period states that it has closed 184 investigations, issued 35 audit reports, and made 137 recommendations for management improvement. Is that correct?
That's correct.
The report mentions, for example, that your office issued an audit of the Department's efforts to address mortgage fraud, and the Department agreed with all 7 of the IG's recommendations. Is that correct?
That's correct.
Your office also examined the FBI's terrorist watch list operations and practices and issued 12 recommendations, all of which the FBI agreed with. Is that correct?
That's correct.
Mr. Horwitz, can you then give us an overview of how these audits and recommendations help streamline costs and improve the Department's programs and operations?
Well, we make these recommendations to do precisely that, Congressman, so that we can not only advise the agency leadership what steps need to be taken, but the Congress itself as it does its oversight. And the recommendations we make go to the deficiencies we find, either management or waste, fraud, misuse, that save the taxpayers every year tens of millions of dollars.
Then it sounds to me like your office is doing a great deal of very valuable work to ensure that the agency maintains high standards of integrity and accountability. I want to commend and thank you again for your efforts, and I thank all of you for being here this morning and clarifying, testifying, and giving us the assurances that we need to have to know that you're doing good work and that the oversight of our government is in good hands. Mr. Chairman, I thank you, and yield back the balance of my time.
I thank the gentleman, and the Chair recognizes himself for 5 minutes. Thank you, all of you, for your testimony. Mr. Elkins, in particular, welcome. It's been a real pleasure to work with you in a nonpartisan way. I think all of us here would agree that we don't want Republicans, Democrats, or unaffiliated or agencies to influence your work, that indeed it needs to be independent, that the American taxpayers depend on your work. And so I just say thank you to each one of you. Ms. Buller, I want to start with you. If this continued stonewalling of access to documents, what kind of harm, potential harm, can you see that would come from this, specifically with your work?
Well, in our case, we do have the Memorandum of Understanding, so we are somewhat receiving information. But the problem with that is it's a temporary measure, and we can't rely on it being there because it can be taken away at any time. And if we don't receive access to the information that we need, we can't ensure the volunteers who have been victims of sexual assault are receiving the types of care and services that they need and are entitled to in order for them to move on with their lives.
So is it your testimony today that victims might potentially continue to suffer if you don't get the kind of access to documents that is outlined in the memo of understanding? But if they quit providing that, could victims continue to be harmed?
We'll never be able to tell. That's the big problem. We won't be able to tell whether or not the agency is doing what it's supposed to do, or whether or not they're actually performing in a poorer manner than they were before. We will be able to tell only from when the victims come in, like they did in 2010, and complain about their treatment by the agency.
So what rationale would be out there to justify, and this question is to all of you, what rationale is out there to preclude you from getting information that would be deemed beneficial to the American people? Why should they withhold stuff from you? Mr. Elkins, we can start with you.
Yes, sir. I think that's a good question, and I scratch my head sometimes trying to figure out the answer to that. But it seems to me that sometimes some of these defenses are made out of whole cloth. You know, they just kind of pop up. You know, based on the circumstances. So it's random, and that's part of the problem.
So there are times when they will very willingly give you information, and then other times where they say you can't have this.
Yeah, I think that's a fair assessment.
Is that because the employees that you have working for the OIG are somewhat inferior to the employees of the agencies?
Oh, no, no.
Well, I would hope that you would answer that in that manner. And so what you're saying is the level and professionalism of your employees would be equal with the agency.
Oh, absolutely.
Do you think that the level of professionalism and privacy concerns within your agency is equal to that of the EPA as a whole?
Absolutely.
Would you agree with that, Mr. Horowitz? Would you say you would have the same desire to protect the integrity of the process?
Absolutely, and we have a track record of handling among the most sensitive national security information that the FBI has through our review of Section 702 of FISA, through various Patriot Act reviews we've done that Congress has mandated. We have among the most sensitive information that exists in our possession.
So there's not a clearance issue here. There's not a propriety issue. And so really there's no reason at all why you should not be getting 100% of what you request.
Absolutely.
And I think, Ms. Buller, you said earlier that there's never been a case where some of that information has been disclosed by the OIG in terms of causing harm to a potential victim. Is that correct?
That's correct.
And so if we have all of these, then what is the real genesis of this whole problem of why they do not want to share it with really the only independent source out there to protect the American people? What is the reason these agencies would do that, Mr. Elkin?
It seems to me that there may be a belief that the IG Act doesn't mean what it says that it means.
So has this been a new revelation that all of a sudden we have this new revelation in the last couple of years that it doesn't mean that, or what? Why did they come to this conclusion recently?
That's a good question, and that's probably one that you'd have.
So we've got new counsel that's interpreting it a little bit differently. So what you're saying is, from a bipartisan standpoint, what we need to do is make sure that the ranking member and the chairman come together and say, well, we mean what we say?
Well, and one other thing, sir, there is no enforcement mechanism in the IG Act.
All right, I'm going to close with this. What would be the great enforcement mechanism? That if they don't give you 100% of the documents, that they get their budget cut by 10%?
Sir, I will leave that up to
I'll certainly yield to the ranking member.
Just one question, Mr. Buller. I'm just trying to figure out what you are able to get under the memorandum of understanding. Let's say, for example, someone is raped. Right now, you can get what can you get?
Right now, we can get access to the restricted report that's filed in the incident report. We may have more difficulty getting other information concerning that particular incident because we don't have a personal identifying number or anything to associate with it.
So you can get the details of the rape. Because I'm kind of confused when I looked at what you agreed to. Go ahead.
With the exception of explicit details, and we've tried to define that MOU very narrowly, salacious things that wouldn't necessarily add anything to our review.
I see. All right. Thank you.
I think the gentleman, the Chair is going to recognize the gentleman from Oklahoma for 4 minutes and at this point.
Thank you, Mr. Chairman. I may not need all that time. I just need to follow up. One of the documents that Mr. Horowitz, you provided was some background information about grand jury investigations, specifically about an Oklahoma case that I want to bring up to you. In the 1990s, the Office of Inspector General at that time requested information about related to an FBI agent's testimony and the Bureau of Prisons related around a gentleman who died in the Federal Bureau of Prisons in Oklahoma named Kenneth Trinidad. That was a very controversial case in many ways in Oklahoma. There was a lot that happened around that case, and still a lot of questions still spin around the death of Kenneth Trinidad in Oklahoma. Your reference to that case, I just want to be able to ask why you're bringing that up at this point, what you have learned from it, what was established then, and what's happening now.
So this is now the 1997-1998 time period, our office was involved in the misconduct review related to that matter. We needed grand jury information, and the Justice Department, Civil Rights Division then, but the Justice Department supported our right of access to grand jury information and went to court, to 2 different Federal judges in Oklahoma, to confirm that the Department's reading of the grand jury statute allowed them to give us those materials. The 2 judges both said, you, Justice Department, are right in your legal interpretation, not the OIG, the Justice Department. And under the law, the IG is entitled to get these grand jury materials. To our mind, that should have resolved this issue. That's now 15 years ago. 2 Federal judges have both ruled. They're Article III judges. We are at a loss to understand why non-constitutional officers would be deciding the issue any differently.
Okay. So fast forward to now today and to what you're dealing with. You're not getting access to grand jury information currently. Is that correct?
The objection is we're not entitled as a matter of law, so we have to go through this mechanism of getting the Attorney General or the Deputy Attorney General's approval to get it.
So at that point, you now have to make a request, and the Attorney General can say, I either want you to have this or I don't want you to have this. It goes back to some of the earlier statements that I made, that he now has the ability to say this helps me or doesn't help me, and so I'm going to give it to you or not give it to you, not based on I've made the request. A Federal judge has already ruled on this in Oklahoma. This has resolved issues. Is that correct or not correct?
It's ultimately left to the decision of the Attorney General or the Deputy Attorney General.
Okay. Rather than I make the request, you're already entitled to that.
Correct.
Okay. So how many cases are out there that are like that for you? Do you have a guess of how many documents or cases that you're either getting delayed response or getting partial response or getting a response at some date in a future time period? Because you had testified earlier that you are getting records. You're just not getting them in a timely manner.
There are probably 10 or more examples I could give of instances where we've either had the legal objection raised or the timeliness issue come up in the last 2 years, at least. I could probably make an even longer list if I went through with my staff.
Okay. Thank you. Mr. Chairman, I appreciate you allowing me to ask that Oklahoma-related question. Thank you.
I thank the gentleman from Oklahoma. The Chair recognizes the ranking member, the gentleman from Maryland, Mr. Cummings.
As we close, I want to thank all of you for being here today. These disputes are very serious because they, without a doubt, impede you from doing your work. On the other hand, of course, you have the agencies, such as I guess in all these cases, who cite laws that conflict with your duties and the rules and regulations that you operate under. It seems like we ought to be able to resolve this. I have 2 concerns, and one is if we were to pass legislation, and sharing your viewpoint, Mr. Elkins, and if it does not prevail, I think that makes your position weaker, your present position. The other thing that I'm concerned about is that if we were to do a universal thing that says your access to information is superior to everything, I don't know what that universe of everything is. You know, and I'm sure you don't either. You may know in your area, but we're talking about 47 of you all. So then considering what the Chairman talked about in executive order, I think the President probably would face the same kind of problem with regard to what that universe is. But there's got to be a way to deal with this. Ms. Buller, the reason why I keep coming back to you is because when we've got an agency that, when you have an IG office whose duty it is to get information and protect these victims and not be trusted with the information, that, it seems like there's something missing there that we ought to be able to get to. The bottom line is, how do we protect victims? How do we get the information that we need so that we can accomplish that? So, we're going to put our heads together and see what we can do to try to resolve these issues. But they are serious issues. I would imagine that if the agencies came in, they probably would say, we really do believe in what we're doing. We're trying to obey the law too. So it's going to take a little bit of effort, but a lot of effort. But I do believe that we should be able to resolve this. Do you all, my last question, do you all believe an executive order is the answer? Ms. Bowler?
I think anything that sends a very strong message to agencies that the IG is there to perform oversight, and in order to provide that oversight, they need access to agency records. Anything that is very clear and states that without exception, I think would help.
Mr. Elkins?
Yeah, I agree that that executive order would be helpful. Also, I'd just like to remind, the panel here that in administrative law cases, there's a very rock-solid case which is called Chevron that agencies rely on to determine whether or not deference should be paid to an agency that has jurisdiction. Well, I think in our case, Chevron would apply as well. The IG Act, we're the subject matter experts there, and there should be a certain amount of deference to our interpretation as to what our access should be. That deference is not given to us. Agencies would use Chevron all the time. But in our circumstance, when we try to assert a Chevron argument, it's ignored.
I would agree with you, Congressman, that a clarification is critical. An executive order, a prompt OLC decision, we've been waiting for a few months now, that would say, what does the law mean? Because that's the objection we're all getting at some level, which is Congress didn't mean in 6A what we all think it means. The FBI is reinterpreting statutes, DEA, others. In my agency, the other inspectors general have said the same thing. Ultimately, they're trying to interpret what Congress meant.
Right.
So it's really all your issue here that you've got the executive branch, in my case OLC, which speaks for the executive branch, trying to divine, does 6A mean what it says as we think has always been the case, at least until 2010, when the FBI General Counsel raised an objection, or what the FBI General Counsel and some others have said. We need clarity on that issue. An executive order would do it. An immediate OLC order would do it. And then Congress can decide whether to fix 6A at that point or not. But that's really what we need.
Again, thank you all very much. Thank you, Mr. Chairman.
I thank the gentleman. I thank each of you for your testimony. I think today highlights really in a bipartisan way the need for full disclosure to the OIGs, not just with your agencies that you oversee, but across the board. Ms. Bowler, some of the testimony that you've given us gives us great pause, because sometimes we look at these things as just administrative, and yet the victims that you have discussed are real. And I don't believe that we can tolerate the lack of cooperation. Ultimately, the information that these agencies have belong to the American taxpayers. They're not proprietary to an agency. They're not proprietary to Congress. They're not even proprietary to you. They belong to the American taxpayers. And what we must do is have full and complete disclosure. To give the best example, if the IRS comes in and does an audit, I don't know the universe of which they may be asking for. When they say they want all the documents, generally they mean all of the documents. And I would suggest that that simple test be one that the agencies hear loud and clear today, that when you request it, they are to provide it. And then we're going to hold you accountable to make sure that those disclosures and the integrity and the professionalism that each one of you have assured me that you have, that gets abided by, because a fracture there really does irreparable harm. We've got a lot of great Federal workers. For many of the American taxpayers, the OIG is the only thing that they can believe in to hold these agencies accountable. Mr. Elkins, you know, in my particular district, I've got an issue that has been going on for 25 years with the EPA. They have no confidence. Democrats, Republicans, unaffiliated, none of them have confidence in that agency to deal with that problem. Their last hope, truly their last hope, is your office and your involvement in the independence of that and the full disclosure is what they're counting on. And so I think that can be echoed across all of the OIGs. And so I thank you for your testimony. I thank the ranking member for his closing comments. And I look forward to you providing to this committee 3 recommendations on how we can help with the enforcement component. The stick or the carrot that we need to have, I need to know 3 suggestions that you might have that we can encourage these agencies to provide what the American people deserve. And with that, I adjourn this hearing.